We want to do him. Oh, like you just have your Zoom screen on, right? Correct.
So I'm just sharing.
Yeah.
Um.
You want me to make him host?
Yeah, he needs to share his screen on Zoom too.
I just make him.
So he's got to share his screen on Zoom so that way they can see, and then we can all see, and then the stream can see.
Yes, I can hear you.
Okay, here we go. Now they have it. The stream will have it. And you probably just need to get it resealed. Whatever's my camera.
Want to make sure it's working. What do you?
Is your volume turned up?
No, I turned mine down because I didn't want the.
Then this will be the setup somehow. Thank you all for being patient.
Can you guys hear us?
Yes.
Okay. Sorry, we're having some issues and we're doing a workaround. It helps if I turn my microphone on.
Are you okay?
Good, yeah, I think, did you have some stuff to do?
You are not going to.
We are live.
Actually, I need to do like this for the live stream.
All right, let's get this party started. Ready? Call to order. This is the Cumberland Planning Commission regular meeting for Thursday, February 12th, 2026. Christine, would you take the roll, please?
Yes, Mr. Brindle,
I'm here.
Ms. Lathrop,
Here.
Ms. Gaskin. Here. Mr. Brady.
Here.
Ms. Pink. Here. Mr. Carroll.
Here.
Mr. Loud. That's 6 constitutes quorum.
There's a white cup that's right in the middle of the screen.
Yeah.
Could you move that?
Here's the next topic of the election of officers.
What, Ted?
There's a white cup with a straw right in the middle of the. There we go. A little bit further. Okay, there we go. Couldn't see everybody.
Good now?
Good.
Well, here, like officers, we'll take some motions. Of course. I'll check.
Okay. Any other nominations? All in favor?
Aye.
Opposed? Ted, you're president again.
Yeah. It's very echoey. It's
Yeah.
hard to hear.
Very.
On that one.
No, unfortunately.
Vice President nominations.
What about Carol?
Any other? All in favor?
Aye. Very good. All right. Wow, so you.
Yeah, it's through Jules.
No.
It might be. They're turning the TV volume on.
Yeah.
Sorry, we're trying to figure out the volume.
Can you hear us?
Yes,
Is that better?
yes.
Yeah, that's better.
Very,
All right.
Good.
That's better too.
Is that it, just president, vice president?
Yeah, and then I'm your secretary, basically.
All right,
Jen.
next is a consideration of the July 23rd minutes. I'm gonna have a motion to accept or any comments.
Make a motion to accept the minutes.
I'll second. All in favor? Aye.
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 Oh, we gotta do it by roll call, don't we?
Yes, I mean, it's gotta be very roll call, because we do it online.
Good call.
Okay.
Mr. Brindle,
Aye.
Ms. Lathrop,
I,
Ms. Gaskin,
Aye.
Mr. Brady,
Aye.
Ms. P,
Aye.
Mr. Carroll,
Aye.
motion carries.
Awesome. Okay, next is any citizens' comments, which I don't believe there are any tonight. Any planning commission member comments?
It was
Ted?
75 degrees here today. We're at sea.
Feel bad for you.
Yeah, that's too bad, really.
I want to see the ocean, and like, you should be outside so we can see the ocean.
Anna
I
wants
have
to see
been
the
all day.
ocean.
From now on, you have to be outside so we can see the ocean. You're gonna be
Well, it's
president.
dark here right now.
Oh, it's dark.
Tough luck.
Okay,
Alright,
any old business to talk about?
not tonight.
Any new business to talk about?
Nope, just our training.
Okay, any other business?
Yeah, we can do, did I do training?
Training isn't, yeah, it's part of the new business.
Okay, yeah, so let's go ahead and we'll turn it over to Jewel and he's gonna give us some training.
Awesome.
All right, so a few months ago, we did some training regarding different statutory procedures, and I said we'd come back and take a look at some other ones, and I'm really focusing on one right now. So that's 3674-1614. This is judicial review. So this is if any plan commission, BZA zoning type of decision goes under a review. The burden of demonstrating the invalidity of a zoning decision is on the
Are we
part.
supposed to be able to see his presentation? Because we can't see it.
Are you sharing on Zoom?
I thought that I was.
We're working on it.
Ted, don't you know this by heart?
There he goes.
Okay,
Yeah.
There we go. We're good.
I can get back to that. So the burden is on demonstrating invalidity, is on the party to demonstrate for the judicial review proceeding asserting the invalidity. So this is just the statute. The validity of the zoning decision shall be determined in accordance with the standards of review provided in this section. So that's what we're talking about here. This goes through, it talks about how the court's going to make a finding of fact on each material issue on which the court's decision is based. And then here's the meat of it. Now, let's talk first about the findings of the court. Whenever there's a review of a zoning type of decision and there's a finding of a court, it is based off of two things. One, the finding has to be based upon some evidence that has been presented to you in your public hearing. So whenever you guys have a hearing, that you're considering something, that public hearing there's got to be something in that hearing that you base your finding upon. And that finding has to be the justification for the ultimate conclusion that you reach, whether that be in your recommendation or whatever. The standard that you look at under this is whether a landowner has been prejudiced. And whether the biggest one is this first one here, whether that is arbitrary and capricious or abuse of discretion. Okay.
We're only seeing slide 1.
Yeah, we're only seeing slide 1.
They don't have.
That's all we see. I see, it looks like your presentation because I can see the slides down the side. But
yeah.
all we can see is slide 1.
Let's choice.
Right.
It says my screen sharing is Paul.
Can I see?
Sure.
That one. And can they see it or no?
There we
Yes.
go.
Looks better.
We're good.
And then if we go back here,
have to do this every time it changes.
I hope not.
That's my
If
slide.
it doesn't go
Is
next
this
time, I'll just turn.
the right one?
green.
That's the
So
slide
it
that
goes
I'm
green.
down.
Okay,
Let's see what happens if I just go to a new slide.
can they see the new slide?
Yes.
Okay,
Yes.
how it works now.
So let's talk about a prejudice to the land. How do we determine that and where does that come from?
Now we look at Christine's computer.
Oh, my goodness.
Right.
Yeah, it's just blank.
It's fine. It's just,
I just don't go blank. Yeah, I see that.
Yeah.
Here
it's fine.
we go.
It's just the top, the label you're not seeing.
I'm fine, audio even, just to keep going.
Okay, so let's talk about prejudice. This is a good thing that I made this training a little bit shorter than the last one, because I just thought you could get through this. So what is prejudice to the landowners? How do we decide this? The best case that is on point for this is actually a BZA case, but it allows us to talk about this a little bit because it brings a lot of things for the planning and department as well. So in this Mammoth Solar versus Elbert case, we're talking about Pulaski County in Indiana. They had passed a UDO that said, if you're going to be a solar energy system type thing or some sort of energy type program, and you're going to put something in our county, these are the regulations on our UDO. You've got to give us where it's going to be. You have to give us a site plan. You have to say how much acreage you're going to be, your proximity to other residential areas. What kind of impact are you going to have and how close are you going to be to residential areas? What kind of noise is going to be? You have all of the stuff that was listed in this UDO that was supposed to be there. Mammoth comes in that wants to put in a solar farm and a wind farm, but a solar farm into Pulaski County. They don't provide a lot of the information that the UDO says you shall provide. As they go through the hearings, both in front of the Plan Commission and then in front of the BCA, a determination is made, you're okay. You don't have to give us that information because we really want to have this investment in our community. They allow it, the landowners sue. Landowners sue and say, we didn't have a lot of this information when you were going through this permitting stage and this early on. We didn't know how close it was going to be to our place, the size of the facility, how high it was going to be, all of this other stuff. And that's going to impact the value of our land. Mammoth said, you didn't need all of that. So this is a question of whether or not the landowner was prejudiced in this process. Mammoth's position. Okay. Mammoth's position was, this is not a question of the landowners. This is a question about the governmental entity. Governmental entity said this and they made the ruling, and so landowners, you don't have a right here. Courts disagreed with Mammoth and the position that they took. They said, no, this language says you shall provide this information. This information was not provided. Because this information was not provided, landowners didn't have all of the information they needed in order to formulate an argument against or for this project. And therefore, they were prejudiced in this proceeding. Because of that, it was turned, they had to go all the way back to the beginning and start over. So that is a case that just talks about the prejudice. Doesn't have to be my property. You don't have to deny me the right on my property to utilize it for me to be prejudiced. It's the decision that can have an impact on my enjoyment of my property. That's where I can show my prejudice, how I've been prejudiced. So standard of review, this is another section that's in the statute that we talk about. So this is the Burgess case. When we talk about a standard of review, when a trial court enters a specific finding of fact and conclusion of law when reviewing a zoning board's decision, Court of Appeals determines first whether the evidence supports the findings, and second, whether the findings support the judgment. This is what we are talking about when you say it's a two-pronged test. In this Burgess case, you had a situation in which there were certain findings made, but they didn't necessarily go to anything, right? But then you had other findings which were right on point. And so the courts went through and they said, first, we have to see if any evidence that was entered into this hearing had a bearing on a finding. And then if it did, does that finding, is it tied to the conclusion that was ultimately reached? So it's a two-pronged test that you go through with that one. And then this Burton case, on judicial review of the zoning board's decision, clear error is demonstrated only where the party seeking relief demonstrates that it was prejudiced by a board of zoning appeals in this situation of arbitrary and capricious, abuse of discretion, or otherwise not in accordance with law, contrary to constitutional right, power, and privilege, excess of statutory jurisdiction and authority or limitations, and then without observance of the procedural required by law, and 5, unsupported by substantial evidence. Those are those things that we saw in that statute, what you attack. When we have this situation, the biggest one, the one that always comes up is arbitrary and capricious. Is it arbitrary and capricious? So that begs the question, what does that really mean? Next slide. So when we talk about arbitrary and capricious, we have this monster trash case. So Christine's going to tell us a little bit about monster trash.
Yeah, so monster trash case, or that case, there was essentially a zoning ordinance that was in place saying that trash companies, it's a non-permitted use unless it has approval from the state agencies that govern those issues, right? And so it didn't say that, you know, trash companies are prohibited uses. It just says it's only permissible if there is a state license associated with it. Well, so Monster Trash was trying to obtain the state licensure that would allow them to operate on those facilities. But the state agencies that were governing, they required that the Monster Trash company provide some sort of evidence or some sort of documentation from the commission saying that there were no zoning, rezoning issues or other variances that they needed to be able to operate on the property that they had purchased. And again, the ordinance didn't say, but it didn't say that you couldn't do it, you just had to have the licensures. But the county refused to provide the documentation, even though there were no rezones, there was nothing, they just refused to provide that documentation. And so when this went up on review, the court was like, they clearly can do this, but you were preventing them from obtaining the one thing that says that they're allowed to do, right? And there is no other reason, there is no other law that would prevent them from doing this. And so your refusal to provide that documentation is literally being the barrier from them continuing on. And so the court instructed the commission to issue that documentation and said that it was clearly arbitrary and capricious, but the landowner was prejudiced specifically because they couldn't operate there. So that type of workaround with commission. They obviously didn't want them operating there and they were hoping to find some way to stop it, but without having the legal authority in there, the courts are very quick to say, no, this, you can't do, I mean, it was a 3-page decision. It was very open and shut from the court's perspective. So we know that we have to be very, sure-footed on the authority that we're relying on if we want to try and deny certain things like that.
And so when we look at decisions that are made, it's very important to know what your local rules allow, when you're making that. So when you talk about the monster trash case, in their rules, you could do this, right? They didn't need anything. And that arbitrary and capricious standard was when the court came back and said, they don't need anything. There's nothing preventing, there's no reason why you should not just say, yeah, they don't need anything. And, but that's what Christine was talking about with that fight. The Lockerbie case is another one where they talk kind of about arbitrary and capricious. This kind of from the different angle of what doesn't rise to arbitrary.
Right, so in this Lockerbie case, if you're not familiar, downtown, there's a historic district, called Lockerbie Square, and so as you can imagine, there are a lot of historic ordinances that, developers and property owners have to comply with to be able to develop on that property. And as with, I'm sure you know, historic, remonstrators, when it comes to historic types of areas, that they can get very vocal, and so there were a lot of remonstrators that came out and said that the Historic Preservation Commission's decision to give a certificate of appropriateness for a developer, they tried to block it. And one of their arguments was that the commission had not, well, they were acting arbitrarily and capriciously because the historic plan, they said governed, and that the commission did not make findings consistent with what the plan required. So the courts, upon review, they look very closely at what the historic plans are, and they scrutinize what evidence is at the hearing that is considered. And they said that, here in this instance, the commissioner or the commission worked for months with this particular developer, going back and forth, honing out all of the different plans, and considered all of the things, documented their consideration of all of the things that were in the historic plan, and made specific findings as to each. And so there, given the long history, given the public hearings that were all had over the course of 6 months or whatever, the court said, you don't like the decision, but you can't say that it was arbitrarily capricious. They expressly considered everything in the statute, in addition to all of the other things that were raised in the hearings, and they made an appropriate finding. So that gave them the basis to move forward.
Yeah, and that Lockerbie case is also one that's relied upon when we talk about supported by substantial evidence, right? What Christine just outlined here is that you have all of this stuff, this decision regarding the application, all of this information. Just because you don't like the information doesn't mean that the court can't rely upon it. Or just because, and this is another angle to it, just because you may have provided information that may be in conflict with the information that was relied upon by the trier of fact. So Christine says this table is going to not meet, the development standards in the zoning area. I say this table is going to meet the development standards in this area. There's evidence now in the record of both. The court can decide what it's going to base its finding upon. And so just because you don't like my opinion, but the court relied upon my opinion, that does not meet the substantial evidence issue or the arbitrary and capricious issue. Evidence just has to be in. Now, in the review of it, we get into some really interesting cases when we talk about review. So when we talk about review, first of all, it's not just, hey, let's look back at it. It is when the appellate courts look at the decisions that have been made by a zoning body, whether it be plan commission or BZA, what standard do they look at? What review? And so that review is a de novo standard. Um, The review is not a trial de novo, and neither the trial court nor the court of appeal may substitute their own judgment. So what does this mean? De novo is a fancy way for that lawyers put together that says like new, right? It's Latin for that. And so a trial de novo means a brand new trial. So you've had your hearing. If it's a de novo proceeding, then we're starting from the beginning, and I can look at the record and I can make my own decisions as to everything that goes through there. That is not what it is in review. This goes back to the arbitrary and capriciousness and then the weight and the substantial amount of evidence. If there is any evidence that the court that made the initial determination can rely upon, there's some evidence for the finding, and that finding is tied to a conclusion, that is enough. I can't say, well, I don't like Christine's position. I like Hannah's better. Too bad. The zoning body made the determination when they heard it. You guys are the ones that were able to see the people testify in front of you, provide the evidence in front of you at your public hearing. You make that decision. That's what the court is going to be bound upon.
And that's really why your findings of fact are so important, why we give you kind of that worksheet where these are the things the court wants to make sure that you're addressing. And so I always encourage you, I mean, you can do the 3 reasons we give you and that's okay. But if there's something specific that helped you come to that conclusion, always make sure you mention that. If something the petitioner says, something someone in the audience says, like that one thing really put it over the top, put that in your motion, because those things help us if we end up in court on a case later.
Yeah, and the last case that I put in here, I want to keep this to 30 minutes or less, and no, you're fine. I think I'm gonna get there. So it's back to the Burton case, which we talked about a little bit earlier. And I stuck this one in here because this is one that I'm seeing more and more around the state of Indiana on all of the different situations. This is a situation, this is a long case where they have all of these different things that go on. And there are a lot of challenges that are brought against this decision that came out from from Madison County. One of the challenges that was brought up is one of the individuals who made a vote should not have voted. So this is where it gets kind of muddy. You have a 5-member board in this case. One of the members recuses themselves. She says, I'm not going to vote on this because one of my very good friends' property is within this area and I don't think I can be impartial. Great. Good job. Way to go. Another member is replaced on the body on like July 19th. But the hearing and the vote happened on July 1st. The challenge was, well, that person can't vote because they were removed off this board. They moved on. Court came down with 2 different findings on this. First of all, on the appeal in front of the trial, in front of the appellate court, is the first time that issue was raised. You don't get to sit on certain issues. If you've got a problem with somebody serving, because they raised issues against people who were hearing it at the trial. If you have a problem against somebody making a determination on the first part, you need to raise it then. You can't just wait and throw something later. Second on this is you can't sit past a trial court and here to raise anything. Third, with this individual, they were an official member of this body at the time that the hearing occurred. Therefore, their determination was final. You can't go ahead, have a hearing, remove somebody afterwards and say that now throw their vote out because we didn't like their vote and have it overturned. So this is a procedural one. And the reason why I'm seeing this more and more is really on the conflicts part of this. The number of cases that are coming into Indiana that are regarding solar farms, wind farms. Now the big thing is the server farms, like data centers. Things that are coming in, whether it be on the planning side to create new text changes to your zoning ordinances, which consider these sorts of things, especially the data farms. There are so many people who have been so active, either for or against this. I have had 3 separate occasions, so 3 different communities across the state of Indiana where I've been contacted to say, can you come and help us fix this? Because we have a problem where one of our members of our plan commission has been a vocal, active advocate fighting against data farms, data centers. And now they are the ones on the websites, they're pushing everything out, they're trying to get everybody ramped up for this. And now they're going to be the ones sitting here trying to make the determination argument. They're great members of the plan commission, but on this issue, can they be fair? And so, and it's funny, one of those communities, I have a feeling, is going to end up in litigation on that exact issue, because there was a fight as to which attorney was going to represent the commission. And it turned out this way, that you had one firm who represented the county and the commission. They had to recuse themselves because somebody in their firm represented the solar farm that was trying to come in. So now the body doesn't have an attorney. The solar farm says, wait a second, you have 2 members on this that are the front runners for fighting against solar farms in this area. We want them to recuse themselves from this vote. They refuse, but they don't have legal counsel to guide them through it. They ask for legal counsel. They bring 3 people to them. I was brought there. This is way up north. And then 2 local groups. One of the local people was one that was presented by the solar farm, who obviously was very much in favor of that solar farm. The other one was somebody presented by one of the 2 people who were said to have a bias. They selected that person, the one that was brought by one of the members, and now those members are voting on this issue. It's going to end up in court and trial. And we'll have another one of these cases to review as to whether or not and what position you should take and how active you should be out there regarding different political issues or issues that the community may see.
I think once this judgment comes down, that's gonna help us as far as, because you always told us before, we make our own decision whether we recuse ourselves.
Yeah.
And sometimes it's obvious, but if it's on the line, are we gonna?
So the ultimate question is whether or not you can be fair and impartial, right? If you-
So I hear what you're saying. In that case, it feels like a black and white case. You have somebody that is like 100% against a data center,
Right.
and yet they say, oh, I'm gonna have a say in this.
Yep.
That seems easy to see, at least from the outside. But where I'm questioning myself, for example, I sit on this commission and I have bias. I'd be lying if I said I didn't. I live in a neighborhood with people that are my friends. I have friends outside of that neighborhood, Anna and I aren't in the same neighborhood. We're friends. And where do you draw the line? It's like those homeowners you talked about. Somebody recused themselves because they had a friend that was going to be influenced. Well, nearly all the decisions we make will affect somebody we know of, an acquaintance, maybe a friend. So that gets difficult. To me, that's gray. That's not as black and white as these cases would make it.
You're absolutely right. The fact that you're asking that question and raising it is a perfect example of why you're probably on this board. Where we run into issues and where we see issues is where somebody lacks that self-awareness to say, hey, I'm going to be influenced. A trier of fact, a judge, a jury, everybody's going to come in with their own personal beliefs, personal biases, and understanding. The question is, can you listen to the facts that are presented at the hearing and be fair in your consideration of that? If you truly believe that you cannot be fair in what is being presented to make your determination, well, at that point, you probably should recuse yourself. But even if you have a bias, so you're coming into this saying, I'm not sure that I'm in favor of this thing, but you're willing to sit there and listen to the evidence, consider the evidence, and apply it to make a finding and then your conclusion, then you're fine to move forward, in my opinion. Where there's a problem is when you this is more of a cautionary tale. When you are appointed to certain boards and positions for a governmental entity, power and privilege comes along with that. Right? You guys are the first gatekeeper when it comes to zoning in Cumberland, period. Right? Anybody wants a rezone, text change, any of that stuff, they come to you first. A lot of power comes with that. My recommendation is this. With that power and that authority comes my best advice would be this: have some restraint in your activity in the public on the advocating of certain issues.
Stay off social media.
I was trying to find a good way to say this, because I don't want to say you lose all your free speech, right?
Right.
No First Amendment for you. But if you are going to be active on social media, don't make it on a zoning sort of issue, right? Don't create the fact pattern for me to, as a lawyer, to go back and say, okay, I got you now because you said back here on this date that you hate wind farms, right? And you would never want a wind farm in your community. And then now you're the one voting. Don't create that record. Stay out of the fray when it comes to that. You want to talk about other stuff? Great. But try and remove yourself from.
And be careful of making like, I will never statements or I hate and things like that, because those can sometimes come back too.
My dead body, yeah, that kind of stuff.
I mean, yeah.
I had something, that happened to me here in Cumberland. This was a long time ago. None of the staff was here. I was on the plan commission. And there was I think it was a minor subdivision that had been approved, and then they wanted to add another lot. They wanted to divide it up into 3 lots. And this was, you know what I'm talking about. It's, I don't know if I remember all the details, but it sat in the front of my neighborhood. And the drainage was gonna go a bit, wind around and go through the creek by my house. And, our engineers said that it should not happen because the drainage was not proper. And so before the hearing, I said, I'm against it, and because of the drainage, you know, and of what the engineer said. So they made me recuse myself because it was by me. And it really made me mad because the point was, you know, the engineer said no. And so I recused myself, and it ended up, then when they went through, platting and all that, oh, they couldn't do 3 lots, they could only do 2, you know, because more things came up with the drainage or whatever. But anyway, I mean, they didn't, you know, I tried to say why they shouldn't recuse me, and they literally almost shoved me out the door and screamed at me. That was a long time ago, different council,
Yeah.
you know,
So I
so.
will tell you this, a recusal is the action of the individual pulling themselves out of the vote. Okay.
Oh, so others can't demand.
They can demand, but
Demand.
you're the only one who decides if you.
Yeah,
want
I just didn't feel like, I mean, I could care less whether it was 2 lots or 3 lots. But the fact that the engineer said the drainage, and to this day, we have drainage issues in that neighborhood. So anyway, you know, I was going on, and, you know, the previous council, they wanted it really, really bad. You know, I got pushed into a few other things a long time ago, which I know. We don't have to worry
I
about
can't
that
imagine
now.
that actually, we just had to work with you for a little bit.
I thought that was right at the very beginning. We didn't have a planner. I would like the planner, you know, so that was a long time ago.
Yeah.
Like 1990, 5 or something.
So what you're saying is in Anna's case, if that were to happen again, people around her are just trying to strong arm her and
It
they
was,
say,
it
you
wasn't,
need to recuse yourself.
it was.
She didn't,
It was the
She would've
council,
meant to.
it was the council and, the attorney at that time.
Wait, but this was in front of was this in front of plan commission or was this in front of the council?
Plan commission,
Plan commission, but the council was telling you to recuse yourself on this?
there was a council member here.
Okay.
So there was a lot of people here. Even one of my neighbors who's an attorney was screaming at me, you have to recuse yourself.
No, so the action of a recusal is the voting member saying, I cannot be, to the extent that when you look at Robert's rules and the rules that should happen, if you are going to recuse yourself, you can't just say, oh, I recuse myself. That's not what to recuse yourself, you are supposed to give the reason why you cannot vote on that.
Yeah,
Because otherwise, you are appointed or elected into this position, and I don't care if it's a hard decision, you need to take action.
Well-
That is the default.
okay, but I said I should not have to recuse myself because I'm going with what the engineer says.
Yeah, if you could,
And I think I was right.
and so I would,
Anyway, that's just kind of a crazy thing, but.
I mean, that's educational too for us now.
Yeah.
Should something like that, heaven forbid, ever happen again.
Yeah,
And if you're ever uncertain, I mean, feel free to call me. I'm probably
Yeah.
gonna
Oh, yeah,
direct you
I
to
will.
talk to the attorneys.
and I'll have you talk to Christie.
yeah, I know. I know
We'll
a
just
lot
pass you
more
on.
now
Yeah.
and, you know, we didn't have the best legal counsel back then either.
Times were
Was
different.
Blake working guys then?
I could tell you who it was.
I mean, it's, that was a dude.
Yeah, it's probably best not to maybe even talk about it ahead of time, like,
Yes.
I'm gonna be against it, just kind of
Yeah.
Yeah.
keep quiet.
Yeah.
You quiet, just take your little.
No reason to.
You will have your opportunity to speak on the issue when the consideration of that comes up. Right? So,
Yeah, and the only thing you can do is they go to the town, get, you know, all the documentation, get the plat, ask questions, you know, staff will help you. I can answer questions, but that's it, you know, so. Like. That's on the plat or whatever, you know.
so with the trainings that we do, this is kind of, I told you we would take bites throughout the year instead of like super long, keep you for 4 hours and go through everything. This is kind of what we're gonna do. We're gonna pick out another statute. We're gonna go through some cases to see how they apply. But does that work? And I realized I didn't keep it under my, I looked at that clock and I thought that I was at 25. This now looked at.
Well, in that case, you
That
have to
doesn't. So, yeah, I'm over where I had target.
That's the cost that's correct. Twice.
Okay?
Thank you.
No, just stop this.
Right.
Should have stopped my sharing, but I think do I have to leave this one on? Because this is the one that's running.
No, the one that's running is
Yes,
Christine's.
this one's
So
better.
if you want to unplug, you are fine.
Okay,
We won't see them. They'll still see us.
If you want to leave the meeting, that's fine.
Okay.
I guess now there's any other business to talk about.
I have some updates for you guys tonight. One, the comprehensive plan, we are on track. The steering committee has met twice now. We're gonna do one more push, to try and get people to take the survey and that. So if you know anyone who, has opinions about our growth moving forward over the next 20 years and they haven't taken the survey yet, you know, encourage them. They can go to the website and take that survey and then we'll be closing that out. The other thing on our radar coming up, January 1 of 2027, Marion County and Cumberland becomes an excluded town. So that means that this board will start hearing zoning cases related to properties in Marion County. So that's something that will be a big change for us. Our comprehensive plan is already working on planning for the entire community. And so as staff, we're working through zoning ordinances, procedures, and all those fun things, trying to figure out how this is all gonna work. And how to marry two completely different codes. And that, so we'll keep you guys posted on that. We've got 2 or 3 kind of different ideas of how we're gonna, potentially run this with some possible long-term solutions. So we may have some stop gaps, by end of the year that we need to put in place. And then, next year have some other things coming, but just wanted you to know we are working on
So
all of that.
I have a question on that. And when I hear you say you're trying to marry 2 sets of codes, I'm not sure what that means. Like, does that mean like any new development has to meet Cumberland? Or are you looking at revising our current codes to be maybe
Mhm.
looser, so things on Marion County fit in a little more?
Not necessarily looser, their code is just written very differently than ours. In some cases, it potentially is a little more detailed because it's a form base in some areas. So we're trying to work through, there's also a longer list of like zoning districts and classifications. And ours is much simpler and shorter than theirs. So we're trying to work through if we assign it one of our existing classifications, what that does, because essentially every property in Marion County, Cumberland is going to become a legal non-conforming use. If we apply our ordinances, which will basically send them to BZA for almost anything. So there's just a lot of different things we have to work through to figure out the best way to approach it, whether that's new codes, whether it's, we don't want to have 2 different codes. We don't want to be applying Marion County and Marion County, Indianapolis is in Marion County and Cumberland and Hancock County. So we're just trying to figure out what that's going to look like. So is it some sort of merging of the 2 codes? Is it adding additional districts for the Marion County piece? Is it starting over from scratch? I mean, we have a bunch of different options. We're kind of working through to figure out what the best recommendations are going to be for you guys.
It's gonna be complicated.
It's fun sitting there with the 2 different codes right now, and we're just going, okay. And then there's so many differences, even just like lot size and setbacks, from here to there. And like none of our residential districts are anywhere near like what we're dealing with over here. There's the Marion County ones actually are probably better than our Hancock County ones, for what's being built today and stuff. So we're just kind of working through all those pieces. And so, I just want you to be aware there are things coming and it's in that, but we're still kind of wrapping our arms around exactly what that's going to look like. It'd be the best approach.
Text changes.
Yes.
That is going to be in front of you guys.
Yep.
And it's going to be a lot of what is less bad possibly.
Yes.
Because,
Yeah.
I mean, it's exactly what Kristen said. You got these, even is the same zoning, so let's say industrial and industrial. Their industrial is different than your industrial, like which definitions apply? Those are the kind of things that you have.
Yeah.
I'm assuming this will just be for anything new coming up. I would think that everything that's in place is grandfathered, right?
Yes and no, yes.
So technically they would be, but what Christine was talking about, legal non-conforming use, if we just say Cumberland zoning ordinance now applies straight for everybody. Almost every piece of property that sits in Marion County is a legal non-conforming use. So that if I want to do anything over there, I gotta come back and ask for special exception or variance or something. Nothing goes with the zone. And so what concerns us from the legal side is, all right, does that open us up to a potential challenge of we're taking somebody's rights away here? And it's a unique situation. It's one thing if you are what I would just say, in Cumberland is different because you guys straddle. I told this to Christine, and then when I first saw it, like, I'm still wrapping my head around this. This is a unique challenge that you don't get for other excluded cities. When you talk about Lawrence, when you talk about Beach Grove, Speedway.
Yeah.
They were in Marion County completely, so they fell under Marion County zoning completely. All their stuff was zoned that way. When they got excluded, they started with the same thing. Here, you got part of your community where we're sitting now is now excluded from Marion County, but you got all this other stuff that has never been part of Marion County, never been.
Mhm,
That's the weird thing that you guys have.
mhm.
So when you say if they're, if we weren't to change anything, they'd come to, BZA for anything needed,
Mhm.
any changes.
They wanna put a fence up, they wanna put a deck up, they
Okay,
wanna
that's
change,
what I-
they wanna
Yeah,
change.
you wanna remodel, you wanna put a new roof on, anything that would
Everything.
require government oversight, all of a sudden, we gotta look at everything, and then if we
Yeah.
do it for one,
wanna
we
put a
gotta
new
do it
sign
for
up at your
another, if we
business.
exclude it for one, then we're showing favoritism and all that.
But,
Yeah.
right, but
I
any
see that.
business, they wanna change their
You
sign,
could
it,
do a taking to where
it
you're,
could be determined.
right, where you're
if
not
we're not
allowing
careful.
a certain use. And I have a real good example of that, that happened to me.
Yeah, so,
No,
right,
it's not town.
Okay.
No, no.
we wouldn't do that here.
It's in Plainfield. It's in Plainfield.
Well, I'm gonna plug my.
Right,
Okay.
yeah.
Okay, looks like every month we'll have like a dozen things on our agenda.
Are you trying to kill me? I mean, we did bring on a new planner. Part of it was because we've been busy, but we're about to get even busier, and some of this is gonna be just really unique, complicated, and it's gonna be probably
It's a
for the,
challenge.
yeah, for the attorneys and planners, it's probably gonna be fun in a way, trying to figure it out, but at the same time, it's gonna be a lot of headaches.
This is the only community that's
Mhm.
in a supplies.
It is, yeah,
Cause you're the only one that straddles a county line that's part of that.
Yep.
So this is a unique experience that
Yeah.
no employer has ever gone through, and no planner has ever.
Like, it's gonna be really hard because you wanna take the least amount of rights away in order to keep people
Yeah.
coming here and living here, but you still need some kind of standard.
right.
We should make.
And trying to do
movie
Zoom.
about this. This would be great. That's like unique.
Yeah, so it's, it's gonna be an interesting year. But I just wanna warn you, there's gonna be some things coming to you guys, and it's probably gonna take a lot to wrap your brains around.
Are you expecting much, lashback, or, I can't imagine.
Depends
so.
on what we do with our ordinances.
At this point, I mean, unless somebody's just got something huge in mind, a developer or a builder out there
Again, I think
that doesn't wanna be.
there's a little bit of that, but then it's also depends on how we write our ordinances, because if everything gets legal non-conforming and you gotta go to the BZA for everything, people are gonna be ticked off.
It's gonna be similar to like when Carmelin was voted historic. Like, I remember my mom like not even being able to change her screen door and like writing.
So anyways, it's a lot that we will have to really just work through. It's gonna be an interesting challenge for us to tackle and try to do it in a way that will work, for everybody. Indianapolis would like us to just keep using their ordinances and let them help us. So they're not gonna be happy with us when we do our own. We're hoping Lawrence does theirs before we have to do ours, but we're probably gonna be the first.
You guys are the first ones, it's kind of a mess.
Yeah. So we're gonna be setting the standard that probably the other excluded cities will end up following down the road. Because right now they're all using Indianapolis's code.
Oh. Oh.
And we're, some of the way that things function within the Unigov system, there's still some things that have to go downtown and that the way their things are set up. And so we're working through all that and what that's gonna do process-wise and things out here. So we're trying to play nice in the same box at the same time. So, and if that wasn't fun enough, the next thing is House Bill 1001. I sent you guys just a short little summary on this beautiful bill. It has a lot in it. It did pass the House. It's been assigned to Senate Judiciary, It has not been called up for committee hearing yet. We're expecting that next week. We'd expected it by now, but it almost has to be next week if it's gonna happen this session. We are anticipating amendments. We've been told that the House and Senate are working on amendments, trying to get to something so it doesn't have to go to committee, which tells me that it's probably happening in some form. So what that looks like, I think we're all waiting to find out, and we're probably gonna have just a day or two to react. Because it's also a 3-day weekend, with President's Day on Monday. And that, so this is kind of how this whole bill has been working is it comes out and 2 days later, there's like a hearing, and so all the communities are like trying to like first understand it and then be able to talk to your representatives, and it's just impossible. The builders and realtors have been working with the state legislature on this for 1.5 years, and kept the municipalities out of it. So,
And the public pretty much.
Because the Home Builders Association has been absolutely genius in how they handle this. In that the Indiana legislative session usually goes from January till a short session March, a long session April or May. It's usually cold during most of that time. So home builders aren't out building homes. So what the home builders have done is they have had a lot of their members run for state office. Within the state house, you have a caucus both in the Senate and in the House that is the Home Builders Caucus, because all of them build homes. That's where this came from. And so you have this Home Builders Caucus create this thing that says local municipalities, you can't have control over the type of houses that we are going to come in there and build. That's how this came. And that's why it's, I mean, it was strategic and it's.
They did a very good job.
Recuse themselves?
No.
They're the ones.
They're the ones that are authoring and sponsoring it.
There could be a class action lawsuit against that?
You can sue
Those
for
are conversations for different days.
Like,
So
like a lot of towns together or something?
That's a,
conversations for another day.
Okay.
it would be great to talk to.
Right? There's a lot of, I was gonna say, there's a lot of conversation happening in the municipal realm right now. Because of this bill. And both, not just what's in it, but then also what we do if it passes, or doesn't pass. Because the reality of it is this is coming back. If it doesn't pass this year, it'll be back next year. And if it passes this year, it's coming back next year to get worse. So don't think we're escaping anything, with whatever the final bill looks like this time. They've been trying for years, but we finally are in a place where the state house does not care about local government right now. It's just kind of where we are at. So there's a lot of things we can opt out of currently in the ordinance as far as regulations for residential design and development. That's everything from lot sizes, density, setbacks to architecture. Landscaping is about one of the only things I feel like that hasn't been touched in there. Otherwise, just about everything else they're trying to deregulate. As it relates to residential, primarily accessory dwelling units, single family homes, and duplexes. They're trying to make it so they don't have to rezone for anything.
That's really scary.
And then beyond that, they can go straight to permit if possible. So even if we opt out, which if there are opt-out options, we will likely opt out, understand our opt-out ordinances will be used against us.
And explain that.
So we have to, one of the new requirements is an annual housing report, and it's got a lot of data we're gonna have to pull. About half of it is data we're not allowed to collect, but we're supposed to pull it from our records from 2025 when we weren't allowed to pull it. And that on housing, how long it takes for projects to get approved, how many we're denying, how many it's a slew
Yeah.
of things, and then that
Depending
is
how long
being
it needs
used.
to be approved, that could be the developer that's
It
slowing
doesn't
things
ma-
down, and that
exactly.
might not even show up.
But we are the blame.
Yeah.
Just to understand. So not only do you have that report that we're gonna have to report on all of these things, but we're gonna have to report on our opt-out ordinances that we do, which basically say we're opting out of these sections of code for these reasons. And those reasons are what they are gonna use next year
I
to
get it.
take this away from us. And that, so when we do our opt-out reasoning, we need to make sure that our justifications, that we know that they're gonna be used against us, that we need to be intentional, and we need to back it up with data. The other thing, I want you to be prepared for with this is that, staff will be coming to you, because I think we have to look at our ordinances, and we need to prepare and look at what they want deregulated and see, are there things that maybe are okay in Cumberland that maybe we make some changes? Do we try to find a balance in the hopes of keeping it from coming back? But we are one of many. And one of the things that we have been hearing at the State House is, well, you know, so-and-so does that. And we're like, well, no, we do it this way. And everybody's like, yeah, but Cumberland's the exception. So there is a recognition that Cumberland is doing a lot of things pro-housing, pro-development, and good things. The problem is we're considered the exception to the rule. And so we will be penalized with everybody else. So whatever we do may not be good enough, but we really are going to need to look at our ordinances, look at accessory dwelling units. Are there districts it's okay to have those? Our residential zoning districts, pretty much everything but an R5 or R6 is only single family homes on lots that I don't know if there's any home in town actually that fits those lot sizes, including, you know, some of our larger lot subdivisions. So are there things in there we should go back and look at? When you look at our PUDs that we've been approving over the last few years, and you look at those standards, none of those projects could be built in one of our zoning classifications today. That's one of their biggest complaints. So should we be readjusting our existing residential zoning classifications when it comes to some of these things? Minimum lot size is a huge one for them. One of the things that they're looking at is that we won't be able to set a minimum lot size at over like 5,000 square feet. You know, one of the things that I know we've talked about, and I've talked about with some other planners that we're all kind of contemplating, is what if we don't worry about lot size, but we focus on maximum density within a zoning district? So there's going to be a lot of things that we'll kind of be bringing you guys this year to talk about, to see what is right for Cumberland. And that just to kind of see where we're at. But I want you guys to be prepared that we can do these things and it still may not be enough. And maybe we'll get lucky and it'll be 2 years before things come back. But I think that this is just a reality of where we're going. There are provisions that will apply regardless we can't opt out of. Those are just as damaging for us. It's changes to impact fees, how long it takes before they can go into effect, the processes. We're only able to look at a mile around where development is, not at like the entire town for parks. They're looking at capping fees for development to 2% of the construction costs of a project. And that's a cumulative. That's your zoning, your platting, your variances, your building permits, your impact fees, all of that, which is probably gonna shift burden to the taxpayers and away from developers, because the fees that we have set up are calculated based on our time and hours that it takes to do these reviews and these things. And right now we have separate fees that like go to Crossroads for our engineering reviews. All that gets added in together. So there's a good chance with the fee stuff, that's one that we haven't seen any shifting on that could get very interesting. And
No,
that,
you'd say it's gonna be proposed at capped at 2%. What would you guess we're at right now?
so some of it's gonna depend on the project.
Just on average, where would you say we fall?
I don't know what the percentage is, because depending on the project, your construction cost is gonna be.
I mean, I'm
it
just
really
wondering,
varies.
like, are we talking about a 0.5% difference, or are we talking about 4% difference?
I don't know that it's 4%, but I don't have a percentage. I would say, on some of the projects, it's, somewhere in the range of $2,000 to $4,000 in permit, in fees we're collecting right now. Because your impact fees, your engineering review fees, that right there is almost 4, and those are probably gonna take the bigger hits. Your plan commission reviews, oftentimes we
Just trying-
hit the, no, I
Is
get
this a
it.
small problem or a big problem?
It's a medium-sized problem, but we do have projects. We have one in town where we already are losing money on it every day because they've had so many revisions, we've had to, they went to construction, didn't use the plans that were approved for construction at their pre-con, like a whole slew of things. And we're out there inspecting all the time. I mean, things that should take 6 months are taking 2 years. And so there's lots of plan reviews, lots of inspections, lots of meetings, lots of phone calls with that project. And I would guess on that project alone, we could be looking at 10 grand we've lost easy, if not more.
I have
There-
a question about, like special districts, like the National Road. Is that something we can opt out of? No.
I mean, yes, we're gonna opt out right now, but no.
There,
Design, it's a design standard. So now the historic conservation district in your HOA covenants will be protected. But from a zoning standpoint, none of it.
The National Road, is that on the National Register of Historic Places?
Only downtown is.
Can we get the rest of it on there?
It's not, it
They
wouldn't
can't.
qualify. It wouldn't qualify, and it's a local historic, yeah. No. Nor do you probably want to go that route. Because then you also have to think through long-term economic development
Yeah,
and implications
yeah,
there.
do that too.
There's a lot of which is worse. Which is the least bad that we're gonna be dealing with. There's also in there, if you adopt or amend your comprehensive plan within 1 year, you have to amend your zoning ordinances to make sure that they apply and align with your comprehensive plan, because if they don't, your comp plan says commercial uses are allowed somewhere, but it's zoned residential, they're not gonna have to rezone because your comp plan is gonna take precedent. So there's gonna be a lot of strategy into timing for adopting our comp plan and then ordinance things that come about. And that, because it's gonna be end of year before, our comp plan will be ready to go through the adoption process, and we may have to delay it, or depending on what things end up looking like, even consider making it an internal document and not formally adopting.
So,
Because then
Our zoning, our current comp plan and our zoning are the same, pretty much now.
yes,
Yeah,
when it gets into your development standards, no.
okay.
And some of your, I'm not sure. Even some of your design standards fully align with what you guys have been talking about.
I'm not saying by any means we keep.
No, but there's,
Curious,
yeah,
like,
trust me.
Before we get it,
Yeah.
the new one adopted in the
Okay.
new ordinance.
Ben and I have been chasing down all kinds of different scenarios, trying to figure out like which direction might be best for us. So like I said, we may come to you guys and be like, hey, I know we spent all this money on a comp plan, but we're not adopting it, and there's a reason for it or, okay, we need to wait until next year. So there's gonna be some strategy involved in some of these things. It's a little crazy. So between the House Bill 1001 and the excluded town stuff, we're at a minimum doing some text amendments, probably entirely new zoning and subdivision control ordinances at some point. But we're also waiting to see what happens with House Bill 1001, because if it looks like we're gonna lose planning and zoning control, do you really want to do new ordinances that are gonna cost you 6 figures? So we're trying to be wise as well with how we recommend you guys move forward on a lot of things. So, if you have questions on any of this, want to talk through any of it, want to know kind of the different places our brains are going, like, feel free. We're happy to sit down and talk to you guys. It's honestly changes on a daily basis right now and things like that. And we haven't even run any of our ideas past attorneys yet. So they may even be like, yeah, no, good try.
No, the other thing that really gets me is the fact that, infrastructure planning. I mean, that is just, like with our comp plan, we want this here and this there and utilities and, depending on what kind of development, that is, and some that, other, I mean, we're in the middle of one and lots of other communities are too, and paying for the comp plan. I mean, it's just
very, very frustrating because it feels like
It's a
comprehensive planning
slippery
is one of
slope.
those right now.
If they're allowed to build whatever they want, wherever they want. Next is, now they'll be able to build however they want.
Mhm. And that's what they're trying to
We
do.
can't regulate
it's all.
materials,
it's- it's
quality. of-
Oh, yeah. That's exactly what they're doing.
And all of a sudden, we just
Yeah.
end up with a bunch of
That's exactly.
Well, and-
disposable homes in our
Well, and then
community.
I wrote my senator, and then what's gonna happen when you have a development that is not the nicest, and in 10 years, it's starting to fall apart, and you've got a really nice subdivision next to it, and then you're gonna lose property values. It's all gonna come back to bite them at some point in time.
I mean, they're trying to get building and fire codes at the state level changed and,
Yeah, I just told you that.
Yeah.
relief there. So we're not, it's not just a local level issue. Luckily, the fire departments have been active when it comes to fire codes, but they're about the only one who've had any success moving the needle on anything at the moment.
Let's hope that, developers will see what the community wants. And then maybe it won't be, but I don't know about that.
That's
Not gonna
good.
hold my
I was
breath.
gonna say,
That's a good thought.
I'm too cynical
Yeah.
to even contemplate that.
Yeah,
It's, as a planner, it's very
That's just so Trump.
disappointing to see what's going on and try to figure out how to best guide you guys, because as much as we want higher standards and would prefer to go that route, the reality is we're going to be fought at every step.
yeah.
So that's all I have. I just wanted to make sure you guys were aware of some things coming down the pike.
Any agenda items for next meeting?
You will have a public hearing next month for a rezoning.
Christine, has there been any
The thing that I
changes in
really
the,
wanna know, and this is a question for our council, is some of the developments that have already been approved. Are they gonna be held to all that?
So unless there's language, we gotta see what the final
Mhm.
draft is.
Okay,
Unless there's language that says this applies retroactively.
Yeah.
Then there will be held to that.
Mhm.
But It might say that this is right.
Yeah.
Okay.
They've been changing dates too, so there's been everything from January 1/27 to January 1/26. So it's hard to tell where that's gonna land. Ted, you had a question?
Yeah, I was wondering, I think we're scheduled for a BZA meeting early next month. Is that still
Mhm.
gonna
Yes.
continue or?
Yeah, as far as I know, they haven't withdrawn.
Okay,
So BZA, the beginning of March, Plan Commission, the end of March.
I
I'll probably talk to you about that when I get home.
Yep.
I said I did contact my state senator about the House bill. So we'll see what I said, at least give me some feedback on something, talk to us.
Yeah.
I told him, I said, Cumberland works hard to get what they have and what we've developed. And somebody else, I said, every community is different. There's no cookie cutter, there's just be no cookie cutter design and all that. And so anyway, I was short, I think, succinct, but we don't want it.
Mhm.
What can you do about it? So we'll see.
Yeah.
If you can answer. So.
Yeah. Thank you.
Take a motion to adjourn. All in favor?
Aye.
Aye.
Oh, shoot, we have to roll call, sorry.
Well,
Mr. Brindle,
Aye.
Ms. Lathrop,
Aye.
Ms. Gaskin, Mr. Brady,
aye.
Ms. P,
Aye.
Mr. Carroll.
Aye.
Now we're adjourned.
We are officially adjourned.
Okay,
You can show
I'm
it.
going to a show.